Hello friends, welcome to my channel. This is Mayank Shah, practicing company secretary based on Ahmedabad, majorly dealing into the corporate litigation matters. In this video, we are going to learn about the jurisdiction of tribunal under the Companies Act. The matters or provisions of the Companies Act where the jurisdiction is vested to the tribunal. Not only that, along with the provisions of the NCLT rules, that is the manner of application, the annexures which are supposed to be made to the application. Not only that, along with the case laws with regards to the same provisions and rules. But before going to the provisions of the Companies Act where the jurisdiction is vested to the tribunal, we should understand how the jurisdiction is vested to the tribunal, how the powers of the tribunal is introduced under the Companies Act. And for that, let's start with that. Under the Companies Act, as we are aware about that, under the Companies Act, the powers of central government has been delegated between the several authorities. Under the Companies Act 1956, out of the said authorities, the authorities are regional directors. There are 7 RTs in India are there at various regions, that is Southern region, RT Chennai is there, Eastern region RT Calcutta is there, Northern region RT Delhi is there, Western region RT Mumbai is there. Along with that, for the 3 RTs, Northwest region RT Ahmedabad, Southeastern region RT Hyderabad and Northeastern region RT Shillong is there. Along with the RT, there is a ROC. Each state have its own ROC except 2 states, that is we know already, Maharashtra and Tamil Nadu, that have 2 ROC. Under the Companies Act 1956, along with the 2, there are 2 more authorities are there where the central government's power has been delegated, and that is Company Law Administration Board, that is Company Law Board, and High Court, to whom the power has been vested and the jurisdiction lies with them under the Companies Act 1956. But with the introduction of the Companies Act 2013, the powers and jurisdiction vested to the High Courts and Company Law Board that are transferred to the tribunal, that is called as a National Company Law Tribunal, and for the same, the chapter has been introduced under the Companies Act, that is chapter number 27, which starts from the section 407 to 434, which talks about the resignation, removal, qualification of members, chairperson. In India, I would also like to inform you that in India there are 15 benches of NCLT. NCLT, first we should understand how the NCLT function. So NCLT, the constitution of NCLT is governed under section 408 and the constitution of NCLT is governed under the 410. How the NCLT function? So every NCLT is presided by the president, and every bench of NCLT is having the combination of judicial and technical. Judicial, that is of civil background, and technical, that is of background of CA, CS professionals. Now, so first, how NCLT function? So NCLT is a quasi-judicial body. What is the meaning of quasi-judicial body that we are aware about? Just to clarify that quasi-judicial body, that means that the powers of NCLT and NCLT's member are the same that of the power of civil court and civil judge that are prescribed given under the Civil Procedure Code 1908. In addition to that powers, the central government or ministry can also prescribe the additional power to for the NCLTs and NCLTs member. So that is with regards to power. Now with regards to main function of quasi-judicial body is the procedure. The function of NCLT is they can decide themselves by way of NCLT rules. So central government can decide the separate procedure, separate function for the NCLT and NCLTs by way of NCLT rules and by way of NCLT's rules. That is NCLT. So likewise, one of the important feature of that separate procedure is under the Civil Procedure Code 1908. As we are aware about, there is a provision under the Civil Procedure Code 1908 regarding review and revision. But under the NCLT rules, there is no provision with regards to revision and review. There is a provision direct to the appeal to the NCLT. Rectification order can be made, but that is tribunal made. Rectification of order, when there is a technical clerical mistake is occurred, opinion mistake is there. So That is all about the NCLT, how the NCLT is functioned. And so for the same job, I have talked about the NCLT sections, the chapter introduced. Along with that, rule has been introduced, NCLT Rule 2016, NCLT Rules 2016, NCLT के स्टाफ के लिए सैलरी अलाउंसेस एंड अदर टर्म्स एंड कंडीशंस रूल्स 2015, एनसीएलटी सैलरी अलाउंसेस एंड अदर टर्म्स एंड कंडीशंस of the chairperson member rules 2015, and the majority of the section under which the NCLT jurisdiction listed that are effective, that are notified in the from the June 2016, and the rules with regards to NCLT that are effective, that are notified from the July 2016. So that is all about the NCLT. There is a 15 bench of NCLT in India are there. Now let's start with the provisions under the Companies Act where the jurisdiction is vested to the tribunal, relevant provisions of NCLT, how the application made, and case law. So first, the provision under the Companies Act where the jurisdiction lies, that is section 7. Section 7 is all about the incorporation of company, as we are aware about. Section 7 subsection 7 which states that without prejudice to 7 subsection 6, which 7 subsection 6 states that wherever the company has been got incorporated by furnishing false information, incorrect information, or suppressing material fact, the company and persons indulge in the same that are liable for the section 447. So उसको prejudice करते बिना subsection 7 कि where the company has been got incorporated by furnishing false information, incorrect information, suppressing any material fact, or the representation which has been made that is a wrong, declaration which has been filed by the professional under the incorporation that proved wrong. So in such a cases, the tribunal can pass on an application made to the tribunal may pass in any of the following order. That is, direct the changes in the memorandum, articles, regulations of the same. Also the management structures, appointment, resignation of directors which are indulged in the misconduct. Second, direct the ROC to remove the name of the company. Also give the order, can also pass an order for the winding up of company. Also give the order to become liability of the members unlimited with. So any of the order, but before passing an order, the tribunal should give the opportunity to the respondent, and also before passing an order should take into consider about the contracts which has been entered into by the company. So this is the whole subsection 7 where the jurisdiction has been vested to the tribunal. Now the manner in which the application can be made, and the manner is prescribed under Rule 66 of NCLT Rules 2016. Where prescribed that if you want to make an application to 7 subsection 7, the application format is NCLT 1. Along with the NCLT 1, that is common that what are the annexures that are supposed to be made, and that is relevant documentary proof. That here in this case, the relevant documentary proof may be the document of the forms which are filed at the time for incorporation of company, the document which are filed as an attachment to the incorporation of company, KYC of promoter, directors, subscribers, the documentary proof on the basis of which you are alleging that the incorrect information has been filed, the fraudulent purpose for which the company has been got incorporated, so that documentary proof. Along with that, the certain draft which are mandatory as per the NCLT benches, like list of dates and events, synopsis, notice of admission, affidavit verifying application, memorandum of affiance, so that are supposed to be attached with the application. On going through the application, the tribunal pass an order for either admit and either dismiss. After admission, give the order that we have learned. On the first hearing, they give the direction to the applicant to serve the copy of application to the respondent, and after which the hearing the parties and give the order. Now let's go for a case law. एक केस में ऐसा हुआ था कि there was a matrimonial dispute going on between the husband and wife. The wife was separated from the husband in the year of 2015. After separation, the wife has also filed several complaints, FIR, before the High Court, before the police stations, and on a consequence of it, the husband has been punished. After being punished, the husband, in order to take the revenge, the husband has opened the bank account with the bank in the name of his wife by furnishing the fabricated documents and by doing the forgery of the sign, has opened the account with the bank. And as with the said bank accounts, he has borrowed the money from the outsiders and against which given the post-dated checks of the bank accounts of his wife, in the name of the bank account of his wife. And after which the said checks have been bounced because of no balance in that bank account. As a result of which the borrower has initiated an action under the negotiable instrument against his wife under section 148. Here also husband has not stopped. He has incorporated a company with his wife as a first director and first subscriber, and also opened the bank account in the name of company, and then he has issued the notice on the name of company to his wife regarding also 148 of negotiable instrument regarding check bounce notices. And after going through the notice, his wife came to found that she is showing as a first director, she is showing as a first subscriber in the company where she has not given consent, where she has not even signed on any of the page, and that's why she has initiated an action and filed a case application before the NCLT Bangalore bench. And after Bangalore bench, NCLT going through the documents attached with the application and going through the documents has came to found that the signature which are appending on the documents which are filed with the incorporation, that are mismatched with the sign which are appearing on the documents which are filed before the family court for divorce case. Not only that, the signature is also mismatched with the proof of identity and proof of address which is filed with the incorporation at the time of incorporation, that is passport, driving license. The signature appearing on that are also differ with the sign which has been showing on the incorporation documents, and that's why here it has been proved that the husband, with the intention of malafide intention, has incorporated the company. And that's why, as a result of which, an NCLT in this case also has asked the question to the professionals, because the professional is signing the subscription sheet and in which it stated that the subscriber has signed before me, and that's why also asked the question to the professionals. So here the learning point is that whenever we are signing any firm, should cross verify at least with the proof of identity and proof of residence. After hearing the case, the NCLT has given order and direct the ROC to remove the name of the company and direct the respondent, that is husband, to pay out all the debt which has been created on the name of company by doing misconduct. This case is not only about the section 7 subsection 7. You can also know that this case can also be the fit case of mismanagement, that is section 241 and 242 case. On the basis of this case, the ROC can also make an application for the winding up of company under section 271C, where on an application by the ROC, on the ground that the company has been got incorporated for fraudulent purpose, the purpose or the affairs has been conducted in a fraudulent manner, or the person who are indulged in the affairs of the company or in the incorporation of the company have been found to the guilty of fraud, misfeasance, and it is just that the company should be wound up. On the ground, the tribunal may pass an order for the winding up. So this case is also can be the case where the ROC can also initiate an action. So this is all about the section 7 subsection 7. Now further section where the jurisdiction vested to the NCLT is section 48. Section 48 is all about the variation in a shareholder's right. So whenever the company has issued more than one class of shares, that is equity shares carry normal rights, equity shares in differential rights, and if the company want to change that shareholders' rights within that class, the company needs to require to take the approval of the holders of carry not less than 3/4 of the class of the shares value. in written or by passing the special resolution at separate meeting. Not only that, if because of the variation in that class of the shares, if the shareholders' rights of another class is also going to be affected, then company also need to require to take the approval of 3/4 of that class of the shareholders. Provided that section 48(2) provided that if the holders of not less than 1/10 of the class of shares, and here not less than 1/10 of the class of shares का मतलब है कि 1/10 of the class of the shares whose rights have been varied, or not less than 1/10 of the shares was also included those whose right have been affected because of variation in other shareholders class of the shareholders other class of the shareholders. So both are entitled to make an application before the tribunal. But here the time limit is within 21 days from the consent, written consent, or within the 21 days from the passing of special resolution. After making in consent, the tribunal gives an opportunity to both company and why company wants to vary and why the shareholders is not agree with the variation. After hearing the case, give the confirm the variation or cancel the variations. Whatever the decision, it will be binding on the shareholders. So here the corresponding rule under the NCLT rules where the application made, the manner of application is prescribed under Rule 68A, where the application format is NCLT 1, but here the applicant is a class of the shareholders. That is not less than 1/10 of the holders of class of the shares, and that's why the applicants are more than one. So here all the applicants are which are aggrieved with the variation, that are authorizing one applicant, and that one applicant is making that application. So here along with the application NCLT 1, the power of attorney which is been signed by all the applicant, and along with that the mandatory document which are supposed to be made in this case, that can be particular for registration document, memorandum articles, terms of the issue document, where the variation is permitted, where the variation is not restricted. First, second, for capital structure for that last year balance sheets where the capital structure specified. Along with that, the terms of the variation for post capital structure on which base of variation. The minutes of the meeting where it has been prescribed that which shareholders have given consent, which shareholders not given consent, which shareholders has consented, which shareholders have not consented, and the justification for the cancellation of variation. After going through the documents, the tribunal at the first hearing direction given to the petitioners that to serve the notice to respondents, and after hearing the case, the tribunal confirm or cancel the variation. So here this is, and the case though is in this case is only that case when the company is issued the equity shares carry the normal voting rights, and equity shares carry the differential right in terms of voting 1:10, where the voting right is 1:10, and if the company wants to alter that 1:10 to 1:15 or 1:5, in that case not only required to take the approval of that class of the shareholders which carry the DVR, also need to require to take the approval of equity shareholders which carry the normal voting right, because both the rights have been affected here. So company need to require to take the approval of both the class of shareholders in this case. So this is the case where the 48 subsection 2 the jurisdiction is vested. For this time that's it, but the subject is here not end, आगे और भी बहुत है. So for that, because आगे inspection inquiry आएगा जिसमें क्या क्या ट्राइब्यूनल्स के पास पावर है, कैसे ट्राइब्यूनल्स इंस्पेक्शन इंक्वायरी भी इनिशिएट कर सकता है, मिसमैनेजमेंट, आगे बहुत कुछ है, वाइंडिंग अप, कंपाउंडिंग. सो जहाँ पर ट्राइब्यूनल का जुरिस्डिक्शन वेस्टेड किया गया है अंडर द कंपनीज एक्ट. सो फॉर दैट स्टे कनेक्टेड, एंड if you like this video, then don't forget to like and subscribe my channel, and till the time, stay connected, stay happy, and stay safe. Goodbye.